the impact of the Apple General Court decisions. We
Sure.
wanna. It's sort of interesting. We thought EU state aid was something EU specific. When we now talk with Hans about it, Hans is sort of a super specialist on the EU law and comes with the connect to Switzerland. You can imagine that is a big challenge for Switzerland to deal with. Ron and I had also a discussion which we will bring to the table during this breakout, where ASEAN is a free trade zone in Asia, where I think one of the countries, Vietnam, is part of that ASEAN top 10 countries or top 11 countries, I believe, Ron.
Yes.
So if and that's a point we want to address as well. If Vietnam comes up with a 10 years tax holiday, how would that feed state aid type of discussions in even regions like ASEAN going forward? So how can we be certain of anything anymore if all these interpretations and very wide interpretations of what we first thought was BAPS only, then it became MLI upon implementation, then it became ATAT upon regional implementation, and suddenly you were crossing the line with EU state aid being a concept applied worldwide. Then obviously the world is looking uglier by the minute. Let's focus on Apple's General Court decision and take the next slide. So we had two companies registered in Ireland, but they were not resident there for tax purposes. So the two companies had branches in Ireland, and the question was, because it had people on the payroll in Ireland, so there was a payroll administration of those Irish companies not resident for tax purposes in Ireland. And the question was, how do we attribute profits to these branches in Ireland? In the course of the period 1991 to 2007, the two rulings came out, advisory opinions. So there was no arm's length principle embodied in Irish local tax law yet. So they were borrowing the arm's length principle from the OECD, yet there was no pure local standard or translation of that arm's length principle in the Irish law and regulations. And they, in those rulings, they agreed on a methodology, namely that the people on the payroll in Ireland of those branches would get a cost plus. If you calculate the cost plus on the 1991 case, there were about 1,000 people of Apple in Ireland. It becomes more or less cost plus 60. So there's a fairly high uplift on operating expenses. And if you look at the later ruling of 2007, it becomes a little bit normalized. By then, there were about 5,000 people of Apple on the ground running a supply chain support hub for the non-US territory. And to my recollection, the cost plus 10 was, and cost plus 20 on some costs were the relevant transfer pricing reference points. So this is sort of setting the stage. The European Commission found that these rulings were state aid and ordered a recovery of such aids. So recovery of such aids, the way the European Commission had calculated what the normal tax would have been compared to what Apple actually paid was I think a $13 billion difference. So quite a lot of money. So that was the in a nutshell the Apple case. If we go to the next slide. So the question is a little bit, if you're in the Directorate of Competition at the European Commission, and as Gunnar already indicated, you have limited resources, you have limited budget to organize a attack on a case like Apple. What is your most successful arguments? So what we did in this case, we said let's look at the arguments they came up with, and then let's look at how strong each of these arguments was compared to what the Republic of Ireland, and I'm sure with some communication with Apple, came up with to defend their case. They obviously, Ireland felt they were doing a proper application of the arm's length principle and a proper application of the based on Article 7 head office branch income attribution report, at least something similar to that on the head office branch income attribution. So the primary argument was that the null allocation of the Apple's group IP licenses to the Irish branch. So they said in the communication between the Irish government and Apple, they should have talked about, so where is your non-US IP located and who's managing it? Isn't that the people who are physically on the payroll in Ireland? You didn't ask for it, so what was your underlying motives not to ask for it? That's a little bit how I'm thinking, trying to think along the lines of what the European Commission, the Directorate of Competition, came up with. So then the second argument, the subsidiary argument, was they felt that the choice of method for allocating profits to the Irish branch was not correct. So basically, almost following suit on the primary argument, but here there's a technical argument as well. They felt cost plus was not the right method, and they challenged the Irish government on allowing Apple to use that cost plus. Although, as I explained on the first ruling, Apple closed in on the cost plus margin was quite generous. I think it even might have put Apple to be in absolute terms, the largest taxpayer in Ireland. Just give some perspective to things. That was an alternative argument. There was no the discretionary manner. So in the absence of any arm's length standard in the Irish law and regulations, the discretionary manner with which the Irish government granted this ruling, that was in those days certainly not a real comparability study performed. It was more like, okay, we want to pay tax here. Maybe we should be one of the largest taxpayers in Ireland. Let's stick our finger in the air and come up with an uplift on costs. I'm sure the reality has been much more sophisticated, but if I smell cost plus 60, then it comes fairly close to that. And the European Commission said, well, this was a little bit too arbitrary, and that risked that created a risk that the profit allocable to the Irish operations was too low and therefore selective and beneficial to, in this case, Apple, so therefore state aid. This is sort of the lineup of arguments, and I just want to open, if Lars joined, to Lars and to Ron, maybe some observations that they might have. Ron, any comments you want to make at this stage, or I can continue as well?
No, it's thinking about it from an ASEAN viewpoint, you're certainly a number of years away from this level of integration. You wouldn't really have the even theoretical mechanisms in ASEAN related to tax. Of course, there's free trade agreements, and that is functioning, but the political aspect of it would be too sensitive to have one member of ASEAN looking at the rulings, and certainly there are rulings that if you were take it out of the practical realm theoretically to look at it where above $100 million investment, the prime minister has a great deal of discretion. They have thresholds, and these things kind of touches on, it would be the largest taxpayer in the country. It would be the largest taxpayer in a certain region. Mm-hmm. So, if you use the same standard, there would be things that could, using the same definition, would come out to be state aid. But from a practical perspective, who would challenge it? They haven't agreed to the level of integration of the EU, so there really wouldn't be that driver. And okay, that would be my opening comment.
Yeah, I think that makes sense. This is 30 years ago, the 1991 ruling in Ireland. There was no point of reference except let's do a fair deal, and so it's not. It's not totally off the grid, these primary, subsidiary, and alternative arguments, I have to say, but they look fairly formal, very legalistic in terms of their approach. They have nothing of the economics analysis you would expect in a regular transfer pricing case where you attribute profits to 1,000 people or 5,000 people in a later stage. If we take it to the next slide, and I try to analyze these arguments. Yeah, sorry. This is the one. So this is the primary argument. The European Commission tried to apply the authorized OECD approach to the attribution of profits to the two branches. So they said the function asset and risk analysis should be applied, and their argumentation was, since the valuable asset is IP, the Apple design and the brand, and no one could be identified in the US managing it, as a process of exclusion, that means, and not having any persons in Bermuda, that means it should have been someone in Ireland. So that was the whole line of reasoning. A couple of observations. The AOA was and still is not part of the Irish legal framework. The European Commission was adopting an approach which is not part of Irish law. We saw that before when we did the generic. The General Court has ruled, though, although the AOA was not part of Irish law, the European Commission can nevertheless use the AOA as a tool to decide whether or not the advantage has been given to a branch of a non-resident company by comparison to a standalone company in Ireland. So this is a threshold you need to go over on the primary argument, which apparently the European the general courts accepted the EC was using this AOA approach. Next slide. So this was the choice of method of allocating profits to the two Irish branches. Both Apple and Ireland commissioned several TP experts to prepare ad hoc TP reports. So a little bit after the facts, they said, okay, let's look, what would a normal activity of 1,000 people or 5,000 people being lead in what is called a strategic supply chain support function, something along those lines. What would the typical role of that be making if you would benchmark it against with taking the functions, assets, and risks of that they carried out an AOA type of approach, and AOA means a two-step approach. What is the activities you can allocate to the branch versus head office, and typically you don't look at the legal reality, you don't look at the financial reality because they're too easy to manipulate. So you look at the people who are physically at the level of the branch, and you look what they are actually doing, and that defines your functional profile of what the branch is doing. Then you apply in the step 2 the TNMM, and you consider in this particular case Ireland to be the less complex parties, and you apply a markup on total cost interquartile for coming up with a reasonable uplift on the OPEX Ireland is reporting. The Irish branches are reporting, and that is where the European Commission attacked these ad hoc TP reports on all its points. And the General Court said, well, you know, we think it's a fair piece of homework. You did not really support another outcome, so bad luck. We will honor the ad hoc TP reports as the only sound standard of this. This is the standard you should adhere to as the proper interpretation of the AOA and the functional analysis, as well as the benchmarks. So next slide. This is on the discretionary manner, and the European Commission concluded that the Irish government had too much discretion, and the court said, well, there's a lack of precision in the methodology applied by Ireland. There's some deviation from maybe a very strictly run, disciplined transfer pricing approach you would do today. The difference in outcomes was a reflection of particular facts in different cases. And as a consequence, the court stated that the mere fact there were no guiding principles for the attribution of profits to the branch does not constitute state aid. And so the discretionary argument was being thrown over by the general courts. So if we take the next slide. The European Commission was allowed to use the authorized OECD approach as a tool. The arm's length principle as a tool to assess whether state aid has been granted was already recognized by the general courts. Although it could have been expected that the general court would have used the same approach in Apple. The novelty here was it was a branch situation. It was not legal entity, so it was different. I think most in the most insightful approach was that under an AOA, there is no warrant for an exclusion approach. And what does that mean? That means if you can't find anyone in the US who was managing the non-US IP rights, it doesn't mean by default, even though there were only 2 Americans visiting Bermuda twice a year to talk about the dividends back to the US, it could not by default mean that the IP had to be attributable to the people on the ground in Ireland. So this is sort of an interesting approach. My takeaways, but I like to hear other views as well, is that a very legalistic approach. 1, 2, no real economic backing of the arguments. So no full value chain analysis by the European Commission, which could have changed the mindset of the European courts or of the general courts, has put the European Commission in a very weak position. Even the interpretation on some of the OECD guidelines they upheld in front of the general courts were corrected by the general courts as a not proper interpretation of some of the transfer pricing guidelines in the first place. So I think it's a fairly poor from a litigation process perspective. It's been a fairly poorly prepared case by the European Commission. A lot of publicity around it, but very narrowly, legalistically, from a competition sort of head-on, not even what the inside seems to indicate, not even with the support of the Department of Taxation in Brussels. So they all did it on their own, which is great if you can do it on your own, but it felt like because they did it on their own, it feels like a legalistic approach of someone who's been trying to do transfer pricing for the first time in their entire life, which is not what you would expect on an important case with 13 billion at stake. So this is a little bit the key takeaways. Any thoughts on that? Any questions? Ron, any points you want to share?
Well, I think it was quite interesting that they're applying a law that doesn't exist in Ireland. Noted also that they didn't do the full value chain analysis. That would raise a lot of issues in Asia on sovereignty, and the principle of ASEAN is generally non-interference with internal affairs, and that would really get a lot of political blowback. When I was reading, I was interested to think, what if they had one person that they could identify as managing the IP, and how would that have impacted the case? I've argued cases where we could identify one employee on payroll, and that did make a substantial difference to the outcome. I mean, it was a very small office, and it was just one person. It was a treaty shopping case. So I was wondering, that how significant that was. But I don't think this will have as much of an impact in Asia. And I did find a little bit of research where they did some, I think it was Deloitte did some surveys, and they said in Singapore, 25% thought this would impact their practice. in China, 30%. So it certainly has less resonance for now than, say, Pillar 2 would have. I think Pillar 2 would have the right mechanisms if you wanted to impact countries in Asia, because 137 countries signed up, so it has that weight authority to it, where I think if you took it to the ASEAN level, they would look at it as meddling in other countries' affairs, something they didn't really sign up for in the tax realm. I don't think there'd be a political will to pursue a state aid approach.
Okay, so basically, I had the question on Pillar 1 and Pillar 2. We raised recently, Ron, if that's sort of the better option to attack cases like this in an ASEAN, where 11 countries create this new free trade zone.
Yeah, and I think Pillar 2 would resonate because, for example, some countries like Vietnam, Myanmar already have a taxation based on non-PE concepts. Just if you have a contractor that has a foreign contractor, they're going to apply a withholding tax. So that would resonate when they see some of the income inclusion, the switchover rules, taxation rules, denying treaty benefits. And again, it's a mixed bag. You've got Singapore with more than 90 treaties, Vietnam 70 plus. Then on the other end of the spectrum, I think Laos is 12, Cambodia I think is 7, and Myanmar is 8. So you really got a wide spectrum of what the impact of treaties really is on these countries. But if they're able to agree on the minimum tax rates and methodology, there's a lot of issues with how do you separate digital income from non-digital income. How do you avoid double taxation? What are the thresholds? But I think that would be a much more palatable way to approach it.
Okay, that makes all the sense in the world. Is there a next slide? I don't even know. Can we move to?
I don't think so.
I don't think so. Huh? So go back one. The question we raised before in the plenary session is obviously what is the ranking of the whole systems, and how will governments be attacking corporates? It seems like the options were early in today's session, we talked about full transparency. And full transparency is good because then you're a good corporate citizen. But then we look at all the measurements, which all that information feeds into an easier assessment by the European Commission, whether there's state aid, an easier assessment under ATAT if any APA gets thrown into a European database and all the tax inspectors see it. It almost seems like a recipe for disaster if you're a corporate, because the multitude of information packages which mandatory go to the tax authorities, and the unclear ranking of tools at the disposal of the tax authorities, plus the interpretation by tax authorities not being so strict in time, so the MLI interpretations get applied to older years as well. You create a tombola, which is quite a big threat to a consensus model the OECD still wants to upheld. So I think if we take it one step back and we look at state aid, I still am wondering whether this state aid approach and the lack of professional attitude at the European Commission, making it a more politically driven tool than anything else, might actually, how to say it in a nice way, we might be better off, and even the European Commission might be better off if they left this tool untouched for the future, or alternatively upgrade and professionalize their approach to things. Because now it's making the beginning of the session, I said, well, let's reflect on state aid after the dust has settled. I think the European Commission was, at least paper-wise through the Financial Times, was responding very itchy when the Apple case was lost. But so far we haven't heard on whether they will go to the next level. But with arguments like this and very formalized legalistic arguments like this, I would recommend they stop this route and just focus on what they're good at, like RTAPs, MLIs, with enough information feed through CBCR, through RTAP, and through this APA pan-European database. That should be sufficient tools for tax authorities to deal with. Again, this is the Department of Competition, and I understand the communication between the Department of Competition and the Department of Taxation is not always that well. So, but that immediately paints the picture. It's really not a tax case we're looking at or the tax approach, but it is a competition case trying to use tax concepts which are, according to our standards, a little bit overdue. So I think that's a little bit the take I'm having as part of this state aid approach. As Ron rightfully says, ASEAN is very unlikely they will go that route because it would take at least 10 years of trusting each other and sharing that level of information, which is not that easy if you have that much diversity in countries. So they're at the early stages of where the European Union was when it became a free trade zone with 6 countries long time ago. So there's still about 30 years to go, Ron, I think, before state aid might
That's fair. That's fair.
Be your trouble zone. I'm conscious of time, but we still have 10 minutes left. So if there's anyone who has a comment or a question, Ron and me are open to it. Anyone? Ron, any final observations on this case from your side?
Well, I think actually it'll be interesting to see how it plays out in the jurisdictions here and what gets lost in translation. One positive sign, I guess, we look at it from the long game. I'm going to make a lecture at the law university about the Starbucks case because the Asian Law Association asked me. One of my interns was working on this and became very interested. So we start transferring some of these ideas down to the next generation. So hopefully, when we have our own cases in 20 years, we'll be in a much better position.
Well, I think you mentioned 20 years, but I think it will be less. The whole digital transformation of our tax workflows will paint a different world, as we saw with the earlier sessions. Once the data starts running, how much tax you need to be paying, a lot of these legalistic tools might be pushed to the background actually, and become less and less often used. For one, because they're so extremely legalistically, economically, and politically difficult that no one really wants to learn the higher details and secrets of the Apple case anymore, because it's too complex for most people. Data is easier, and in 5, maybe even earlier date, 5 years from now. Okay, I think thank you very much for this participation, and thanks, Ron, for being a good presenter, and staying up this late. I know it's a little bit later at you. I think with this, I don't see any more messages or questions coming in. I would like to thank everyone, and there might be a plenary final words by Hans. So if people want to stick around for another 7 minutes, fine. If you want to dash off and start enjoying the evening, enjoy your evening, and great to have you here, and hopefully great to see you back on one of our next events. Thank you very much.